Good afternoon. Welcome to the Analyst. Today we'll be taking up 6 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll take up is related to the environmental impact assessment and the retrospective environmental clearances, as the Supreme Court quashed a 2021 office memorandum which allowed the granting of ex post facto environmental clearances. The second article is related to the gig economy, as India abstained from voting in the ILO Convention number 193, the decent work in the platform economy. In the mains value addition section, we'll have a discussion on the insurance related schemes in India. Additionally, we'll take up 4 articles in the prelims pointers which will be helpful for your prelims preparation. The first article is related to the environmental impact assessment and the retrospective environmental clearances, as the Supreme Court quashed a 2021 office memorandum which allowed the granting of ex post facto environmental clearances. Therefore, we'll observe the process of environmental impact assessment in India, the evolution of regulations related to EIA in India, the international principles in this regard, the judicial observations related to environmental protection and EIA, and also a few suggestions as well. This is important in GS3 under the topic conservation, environmental pollution and degradation, and environmental impact assessment. First, let us observe the process of EIA in India. Every individual seeks development, every nation wants development, but the development also comes at a cost. And that cost is ultimately borne by the Mother Earth, because when we are taking up any projects, infrastructure projects, linear projects, they cause some damage to the environment. Now, the environmental impact assessment is a tool in the hands of the authorities to anticipate that potential damage to the environment which will be caused because of that developmental project, and to also come up with the mitigation measures, mitigation strategies to minimize the damage to the environment. In India, we came up with the studies related to the impacts upon the environment ever since the 1970s, when we were also implementing the River Valley projects, and subsequently the Impact Assessment Agency was also established under the Ministry of Environment, Forest and Climate Change. Now, what is the process that we follow? First, there is a screening which is done to determine whether an EIA is even required for that project. It depends upon the size, the probable impact of that project upon the environment. If it is negligible, EIA may not even be needed. Then scoping is done. The scoping is done to determine what are the probable issues which may be caused due to the implementation of that project. What are the terms of reference for the study? A comprehensive study will have to be taken up so that the impact assessment is done. The impact assessment is done to determine what are the positives from that project, the developmental benefits which will be derived if that project is implemented. What are the negatives, the negative impact upon the environment because of the implementation of that project, and therefore we need to come up with the mitigation measures as well. And there is also the participation of the Gram Sabha, the public participation in the environmental impact assessment. And subsequently, after analyzing everything, the report is prepared which contains all the data, the probable impact upon the environment, the probable benefits derived from the project, and subsequently therefore an environmental impact statement is prepared which contains all the information, and it serves as a tool for the decision making which is done by the authorities. Even after the granting of the clearance for the project, there is continuous monitoring which is done. There is compliance which is needed to ensure that if there was conditional grant of the environmental clearance for that project, those conditions are fulfilled when the project is implemented. Now, let us also observe the impact of the Constitution upon the evolution of EIA in India. Initially, we did not have explicit provisions in the Constitution because immediately after gaining independence, we had other priorities. We had the developmental priorities, but there was that spirit of environmentalism that was introduced into the Constitution also subsequently, particularly from the 42nd Amendment onwards. From the 42nd Amendment onwards, for example, the Article 48A was included into the Constitution, which imposed a duty upon the state to protect and preserve the natural environment, forest, wildlife, etc. Similarly, the Article 51AG which imposed a duty, a fundamental duty upon the citizens also to protect and preserve the natural environment. And then the judiciary also played its role. Its interpretation of the rights they have been expanding. For example, the interpretation of Article 21, that the right to life and personal liberty, that was broadly interpreted, that was liberally interpreted to include even the right to a clean and healthy environment. For example, through a series of case laws like MC Mehta versus Union of India, Subhash Kumar versus State of Bihar, etc. And the judiciary also balanced the rights. For example, there is a right to freedom of trade and profession, the rights under Article 19, Clause 1, Clause G, and it has to be balanced with the rights of the others under Article 14, Article 19, Article 21 or Article 51A, Clause G, etc. And we also have the Article 253, through which the Parliament can enact a law in continuation of the implementation of various international treaties, international laws, etc. And there are various doctrines which were again evolved through the judiciary. For example, the precautionary principle. The Supreme Court invoked the precautionary principle in various cases. For example, the Taj Mahal case. Again, therefore, imposing the burden of proof upon the polluter. They need to prove that the project that they are taking up, it is not causing serious environmental damage or serious adverse climatic impact or environmental impact, etc. Similarly, the development has to be sustainable in nature, and the public trust doctrine as well, through which it is observed that the state, it is the trustee of the natural resources. Therefore, the state is obligated, since the state is the trustee of the natural resources, it is obligated to protect them for the public good. Now let us observe how have the regulations related to the environmental impact assessment in India evolved over time. Initially, there were no explicit notifications or regulations till that period, particularly before 1994. It was the judiciary which was playing its role. The judicial scrutiny was done to ensure that there is no significant environmental damage caused due to large projects. But from 1994 onwards, there were notifications. The EIA notification in 1994, it mandated the environmental clearance for the listed projects. Therefore, the Impact Assessment Agency was established under the Ministry of Environment and Forest. But there were certain flaws in the notification of 1994. These flaws were highlighted by the Govindarajan Committee, that this notification has led to a process which is cumbersome and it is slow. Because of the slow granting of the clearances, it leads to the delays in the projects, and these delays lead to further cost overruns. Also, the EIAs which were done, they were of poor quality, because the reports that were prepared, some of them were even plagiarized. For example, the Ratnagiri related EIA, that was copied and pasted from the Russian EIAs. Similarly, the basis was investment base, that if there is significant investment for a project, then the EIA will be mandated. But there are small scale projects also which require lesser investment. They also can cause huge environmental damage. So rather than considering the impact, the potential impact upon the environment, the investment was made the criteria whether the EIA is needed for the project or not. Then there were some amendments done to the 1994 notification to strengthen it, that the public hearings were required after 1997 and the location sensitive clauses were introduced. For example, the Aravali mining, the clauses were introduced that if it is an eco-sensitive zone, there should be stricter norms. For example, the mining near the Aravali areas, the Suraj Kund, Badkal Lake, etc. But there was a dilution also through the 2002 amendment, which included dilutions. For example, the projects which involve the investment of less than 100 crore rupees, they do not require EIA. Similarly, the small scale projects, they were exempted. Subsequently, in 2006, there was a major overhaul. The notification of 2006 EIA notification, it led to more decentralization in terms of the granting of the clearances, environmental clearances for the projects. That the projects were divided into category A and category B projects. The category A projects were major projects, they required the central appraisal, whereas the category B projects, they required only the state level appraisal, the appraisal by the environmental appraisal committees. And the process that was also improved subsequently, as the public consultation that was made more transparent, and there were shortcomings even after that. For example, the public participation, it remained weak. The authorities did not participate, and the post monitoring after the granting of the clearance for that project, the monitoring was also not up to the mark. Plus there was even a reliance placed upon the ethics of the proponent of the project. For example, if there is a delay in the forming of the terms of reference for the study by the environmental assessment committee, then it can be prepared by the proponent of the project itself and it could be relied upon, but they themselves have a conflict of interest. So this led to a critical shortcoming. Then through the notification of 2009, more measures were introduced to enhance the transparency. For example, if certain conditions were imposed for the granting of clearance, the environmental clearance for a project, they had to be published by the proponent of the project in the local newspapers or even on their website also to ensure sufficient transparency. Plus the categorization of the projects, that was further refined. For example, different degree of clearance was required for certain projects, for example, mining, national highways, etc. But there are certain issues which remained persistent, like the politicization of the committees, the environmental assessment committees, their appointment, there is nepotism there. Plus there is a lack of cumulative assessment. When the environmental impact assessment is done for granting clearance to a project, only the impact of that singular project is considered, rather than considering the cumulative impact of all the projects in that region upon the environment. Plus the social impact also needs to be considered. Additionally, the health impact studies, they remained inadequate because there is lack of representation of the public health professionals in the environmental assessment committees. Therefore, the impact of the projects upon the public health, that was not adequately documented. You can consider the case study of Char Dham project also, that was related to the road widening, the roads connecting the Char Dhams, Kedarnath, Badrinath, Gangotri and Yamunotri. That project was broken down into more than 50 civil works, so that lesser degree of scrutiny is done related to the environmental clearance for the linear project. Then there was the draft EIA notification of 2020 also, which allowed the ex post facto clearances, the environmental clearances, once the projects have been started, implemented, even without getting the environmental clearance. But that was subsequently struck down by the Supreme Court in the Alembic Pharmaceuticals case. Also, there was an erosion of the public participation. How? That there was exemption created for the strategic projects. Again, this remains vague, the definition remains vague. And also the capacity enhancement exemption was created, that if there are existing projects for which the capacity is sought to be enhanced up to 50%, then no fresh public hearings will be required. And the reporting of violations, again here it has to be done either by the project proponent or the government himself. The public has no direct recourse, which creates a perverse incentive for the project proponents. Also, the compliance was also diluted, plus there were mass exemptions which were created. For example, related to the compliance, earlier it was required for half yearly, then it was increased to yearly compliance assessments. Now let us also observe the judicial approach related to the environmental protection and the implementation of the EIA in India. Through the Narmada Bachao Andolan versus Union of India case, the court observed, that was related to the Sardar Sarovar Dam, that we need to apply a balancing test. That the priorities, developmental priorities, the national priorities, for example, the availability of the irrigation water, the drinking water, that has to be considered when you are considering the environmental impact of the construction of that dam. Therefore, the court allowed the conditional construction that up to 90 meters height it can be constructed. After 90 meters, the environmental impact assessment and clearance will be required. Also, the court observed that the monitoring mandate has to be there, that during construction and after that also the monitoring has to be done related to the implementation in related to the conditions for the project. In the KM Chinnappa versus Union of India case, that is related to the Kudremukh mining, the court observed that the environmental impact assessment is mandatory, and wherever there are violations, the project has to be stopped. Similarly, in MC Mehta versus Union of India case, the court observed that the zero tolerance has to be adopted for the violations. that was related to the Taj corridor case, and the scrutiny can be taken up even ex post facto also. Even after the projects have been implemented, their damage to the environment can be assessed even after that. In again MC Mehta versus Union of India, the Aravali mining case, the court observed that the precautionary principle has to be applied. Therefore, the mining has to be done in a sustainable manner. The sustainable development test has to be applied, that wherever the mining can be done while balancing the ecological impact, then it can be allowed, otherwise it has to be banned while considering the mining near the Surajkund or the Bhadkal Lake areas. In Lafarge mining case, the Meghalaya mining, the court observed that the Ministry of Environment Forest, although it has taken due diligence into account while granting the clearance, but the procedure for the environmental impact assessment through the Ministry of Environment Forest itself, there are certain shortcomings in that. Therefore, there should be a national regulator. An independent national regulator must be established, which should be granting the clearancing for such projects. In Deepak Kumar versus State of Haryana, that's related to the sand mining case, the court again observed that the environmental clearance is required even for the mining of the minor minerals as well. In Sundarajan versus Union of India case, that is related to the Kudankulam nuclear power plant, the court observed that the safety assessments which are done by the expert committees, they will override the obligations, the objections from the side of the public. The public opposition can be overridden via the safety assessments done by the experts. In Alaknanda hydropower projects, the court observed, related to the Srinagar Dam construction, that the application of the EIA regulations can be done only prospectively. For example, prior to 1994 itself, the construction of the dam was done to the level of almost 95%. At that time, there were no requirements related to the environmental impact assessment related notifications of 1994. Therefore, those notification related requirements cannot be applied retrospectively, although the court imposed the moratorium on the further construction related to the hydropower projects in Uttarakhand subsequently in that case. In Sterlite Industries versus Union of India, the court observed, related to the Tuticorin project, that the old clearances, they will remain valid. Therefore, if the clearance has been given based upon the environmental impact assessment notification which was in practice at that time, that will remain valid. If there is a further amendment in future, there will be no retrospective application. Because this plant had got the environmental impact assessment clearance under the 1994 notification, but there was an amendment in 2006, but the criteria for the 2006 notification cannot be applied for this case, because at the time of 1994 notification, only rapid EIAs was required for such projects, and therefore the public hearings were not done. In the Orissa mining case, the Vedanta Niyamgiri Hills mining case, the court observed that while granting the environmental clearances, the tribal rights have to be protected. They remain paramount. Their rights have to be protected under the Forest Rights Act, and after getting the consent of the Gram Sabha, then only the mining clearances can be given in that region. In Alembic Pharmaceuticals case, the court observed that the ex post facto granting of environmental clearances is illegal. This has been upheld once again by the Supreme Court now, and therefore the principle of proportionality also needs to be considered. In the Alembic Pharmaceuticals case, the court did not close down the plant. The court merely imposed heavy penalties considering the investment in the construction of the plant plus the employment of the people involved in that region. Now let us observe certain international principles related to the EIA. Through the Stockholm Declaration 1972, particularly Principle 21, there was an emphasis placed upon the responsibility of the states, the responsibility to prevent the transboundary pollution. Through the Brundtland Report of 1987, there was an emphasis upon the linkage between the economic development and the environmental limits that need to be considered before going for the developmental projects. The Rio Declaration Principle 17 observed that the projects which have a significant adverse impact upon the environment, for that the EIA must be done by the states. The Agenda 21 encouraged the states to implement it as a policy measure and to also ensure that there is public participation which is done when granting the clearances, when going for the studies related to the environmental impact assessment. Also, the World Summit on Sustainable Development emphasized upon the EIA and the sustainability of the development, and the Earth Summit 2012, the Rio Plus 20 Summit as it is known, emphasized upon the development of the green economy and ensuring that the development is in line with the sustainability. The international instruments have also emphasized upon the EIA. For example, the ESPO Convention, again it is related to the states' responsibilities for the prevention of the transboundary pollution, and the UN clause through Article 206 especially encourages the states to prevent the marine pollution, as well as the Paris Agreement, which again ensures that the states are committed towards the climate change targets. The EIA also has a role in ensuring the sustainable development, as we can observe that for ensuring the sustainable development objectives, we need to ensure that the environmental issues are settled with the participation of the people, and the verification of the projects is done in terms of the fulfilling of the conditions related to the environmental preservation and protection. Now, what are the suggestions that we can give regarding the implementation of EIA in India? First, there has to be an independent regulatory body rather than the exercise of the environmental impact assessment under the domain of the Ministry of Environment, Forest and Climate Change. Plus, there has to be a transparency in the public consultation. For example, we can implement something like consent certificates. We can integrate the environmental impact assessment with the social impact assessment and also do a cumulative impact assessment. For example, when granting the clearance, we should not consider only the impact of that single project, the impact upon the environment. Rather, there has to be a cumulative impact assessment study related to all the projects in that region. Plus, there has to be a solid post-monitoring mechanism that the conditional clearances, if granted, then the conditions must be fulfilled during the implementation and after that. And the accountability of the authorities has to be established, and there should be a new comprehensive legislation regarding the same. Now, coming to the article, the Supreme Court has quashed the 2021 Office Memorandum, which had allowed the granting of ex post facto environmental clearances to the infrastructure projects. But now the court observed that the union government cannot substantially alter the protective environmental checks by issuing mere administrative instructions, because it is substantially altering the nature of inquiry and the criteria for the grant of environmental clearances under the 2006 notification, and it is rather supplanting an earlier delegated legislation, the 2006 notification, through an administrative instruction which is not allowed in law. An amnesty measure cannot become a permanent parallel route to circumvent the prior environmental clearance regime as was put in place through the 2006 EIA notification. There is a mains practice question also. Discuss the evolution of the EIA framework in India, analyze the role of the judiciary in shaping the EIA norms, and suggest measures to strengthen the EIA process to ensure sustainable development. Please try to write it. The next article is related to the gig economy in India. As India abstained in the voting for the ILO Convention number 193, decent work in the platform economy. Therefore, we'll observe the status of the gig economy in India, the significance, the benefits due to the gig economy, the challenges faced by the gig workers, and a few suggestions in this regard. This is important in GS3 under the topic Indian economy and issues related to planning, mobilization of resources, growth, development, and employment. First, let us observe what does the gig economy mean. It involves the gig work, which involves the short-term engagements, that the startups, for example, or the platforms, they hire the workers for short-term engagements and they hire them for specific tasks, specific projects. Therefore, they allow them for flexible work arrangements, work from home arrangements, or the flexible working hours, etc. Now, the type of gig work, it can be either the platform-based workers, for example, various digital platforms, app-based platforms which provide the various jobs, and there can be non-platform gig workers also. When we observe the status of the gig economy in India, as of 2020-2021 itself, there were about 7.7 million workers which were involved in the gig economy in India. As per the estimates of the Niti Aayog, it is expected to increase to 23.5 million gig workers in India by 2029-2030. And we can observe another trend, that the medium skilled level jobs in the gig economy, they have declined over time, and the low skilled jobs and the high skilled occupations, they have increased. Now let us observe the drivers of the growth which has led to the flourishing of the gig economy in India. First, there has been technological adoption, the advancement in technology. For example, the mushrooming of the online marketplaces, various digital platforms which allow the remote-based jobs, work from home, for example, online tutoring. Similarly, there have been various gig platforms which allow the app-based work, Ola, Uber, Zomato, Swiggy, etc. And the job market itself has experienced fluctuations. There is uncertainty, particularly after the pandemic, the COVID-19 pandemic. Therefore, the demand for more remote jobs, also the work from home, etc. And the startup culture, that has also promoted the gig economy to an extent, because they have also employed people on a contractual basis rather than creating permanent employment, employing them on the project-based work. The government initiatives have also led us to this direction. For example, the Digital India, which led to more internet penetration also, and the Startup India, etc. Now coming to the article, the ILO Convention number 193, Decent Work in the Platform Economy, is the first binding international treaty which is written for the gig workers like rider, driver, picker, data labeler who earn the livings through an app. India abstained from voting under it. Under the ILO tripartite system, each country votes through 3 delegates. Only India's government abstained, but the employer delegates and the worker delegates, they voted in favor of the adoption of the ILO convention. And what does the convention prescribe? It extends a floor of rights to the platform workers, regardless of their classification. Whether the company classifies them as employees or independent partners, they should have minimum rights, and they should have some core protections. The core protections including the pay which is as per the statutory minimum or the negotiated minimum pay, on time payment, occupational safety and health, social security, and that should be on similar terms as the other workers, the permanent employees, etc. Apart from that, the convention also enters into a territory which no other global standard has entered, that is algorithmic management, that the opaque softwares are used by the apps which allocate the work, which set the pay, which monitor the performance, and which silently deactivate their accounts. Now the platforms must disclose the automated decisions, explain them in writing, and also keep a human being in the loop. Let us also observe the significance of the gig economy, why it is important. For the organizations, it is beneficial because they cut the operational cost, because they are able to outsource the short-term tasks. The project-based work, it can be outsourced. Therefore, they do not need to go for long-term commitment for their permanent employees like the pensions, PF, etc. And there is therefore agility in the size of the team, size of the organization, and the composition. Therefore, they are able to come up with more innovative measures and protect their costs. For the workers also, it is beneficial to an extent. For example, they get the flexibility of when to work, where to work, or how much to work. They can choose, and there will be a non-discriminatory access through the platforms, and the income stream that can be diversified. They can have additional income, they can have multiple income streams by engaging in multiple gig works. There can be socio-economic benefits also. For example, the labor participation for the women, for the students, that will increase. Why? Because some of them are available for part-time work, work from home, etc. And it may cause regional development also because of the increasing gig work in the tier 2, tier 3 cities as well. But there are certain challenges in the gig economy. For example, there is income instability. Like the Minimum Wages Act, it prescribes the minimum wages for the formal employees, but the income protection for the gig employees is not there. Similarly, the job security is not there. They may not receive the work if the platform deactivates their accounts. There is little social security available. The social security net is limited. For example, the health insurance, pensions, paid leave, etc. These are available for the permanent employees, not for the gig workers of the organizations. And it may cause further informalization of the labor. And the informalization of the labor will further reduce their bargaining power. And because there is already scattered unionization, because they are not permanent employees, they are gig workers, the unions are also scattered. The regulatory protection remains limited. There is regional disparity also. For example, wherever there is internet penetration, there the access to the gig opportunities will be better, and therefore it may further perpetuate the urban-rural digital divide as well. Plus, the algorithmic control remains opaque. The softwares that the platforms use, the app use, that remains opaque, and sometimes they penalize the workers without explanations. For example, cut in pay, or their ratings, or even deactivating their accounts, etc. Now, what are the steps that have been taken already for the gig economy? Through the Code on Social Security, there is the definition of the gig workers, and it ensures the life cover and the disability cover for the gig workers as well, and seeks to provide them accident insurance. Through the eShram portal, the national portal established since 2021, it is for the unorganized workers, including the gig workers, to provide them access to the government welfare schemes and the social security benefits. The National Social Security Board oversees the implementation of the social security for both organized sector plus the unorganized sector, including the gig workers. And it also recommends the welfare schemes for the implementation for the gig workers. There are various states also which have now started coming up with the initiatives for the welfare of the gig workers. For example, Rajasthan Platform-Based Gig Workers Registration and Welfare Act of 2023. Through this, the employers and the aggregators, they are required to deposit a monthly welfare cess. This will be used for the benefit for the development for the gig workers. Now, what are the suggestions that we can give regarding the gig economy? First, there have to be more stringent regulatory measures. There have to be more protective measures, for example, minimum wages, working hours, and also ensuring paid leaves for the gig workers. The fiscal incentives can be created. For the employers, for the businesses, the tax holidays can be given. Social security needs to be widened. For example, mandatory coverage can be provided for the gig workers under the Pradhan Mantri Jan Arogya Yojana and also Pradhan Mantri Jeevan Jyoti Bima Yojana. The protection can be given from the algorithmic abuse also. For example, the abuse related to arbitrary deactivation of accounts, wage reductions. For that, there has to be better transparency related measures, transparency in the ratings, transparency in the incentives provided. Also, the gig workers can be provided more training, skill-based training, so that they can upgrade from the medium skill jobs to the high skill jobs as well. There is a main practice question also. The gig economy is emerging as a significant driver of employment and economic growth in India. However, there are also concerns regarding the labor rights, social security, and regulatory oversight. So, discuss the significance of the gig economy, examine the challenges associated with its growth. Please try to write it. In the mains value addition section, we'll have a discussion upon the insurance schemes in India, as the Insurance Regulatory and Development Authority has been bringing in reforms in the insurance sector in India. First, let us observe the health insurance related schemes. There is the Ayushman Bharat Pradhan Mantri Jan Arogya Yojana. It provides 5 lakh rupees benefit through the annual cashless hospitalization cover. It is provided for more than 50 crore poor people in India. Through the Rashtriya Swasthya Bima Yojana, the BPL families, the below poverty line families, are covered, and they are provided smart card based cashless hospitalization benefits. Through the Employee State Insurance Scheme, the healthcare, maternity and disability benefits are provided to the formal sector workers who are earning less than 21,000 rupees per month. Let us observe the crop insurance related schemes. The significant Pradhan Mantri Fasal Bima Yojana, which was launched in 2016, provides for compensation for the crop loss in case it is due to the natural calamities. and it covers the kharif crops for which 2% of the sum insured is to be paid, rabi crops for which 1.5% is to be paid, and the commercial crops for which 5% of the sum insured is to be paid, and the remaining premium it is subsidized by the center plus the states, and it covers the pre-sowing losses also and the post-harvest losses as well. And therefore the assessment is done when compensation is to be given through remote sensing, drones, GPS for faster claim assessment and ensuring the transparency. Related to the Jeevan Jyoti Bima Yojana, it provides the natural and accidental death risk coverage, and 2 lakh rupees coverage is provided to the saving bank account holders of the age 18 to 50, and rupees 330 per annum is to be paid as premium. Suraksha Bima Yojana covers people from 18 to 70 years of age. For this only 20 rupees per annum is to be paid as premium, and 2 lakh rupees is given if there is full disability or there is accidental death. Atal Pension Yojana seeks to ensure minimum pension after the 60 years of age, and it is provided to the spouse after the death of the pensioner, and it is for the coverage of the unorganized sector. The next article is related to the Foreign Contribution Regulation Bill 2026. This is important in prelims under the topic Indian Polity and Governance. Before coming to the article, let us observe the background, the evolution of the foreign contribution regulations in India. It was introduced originally in 1976 during the time of the emergency to keep track of the foreign influence in the Indian domestic politics, to ensure that there is no foreign hand in the disruption of the Indian democracy, to track the foreign influence in the social, political, economic and religious decisions. But at that time also the non-profits were allowed to freely receive the foreign donations while just reporting the amount that they received and spent every year. But from 1984 onwards, it became mandatory for the non-profits to register first before they can receive the foreign donations, and also they could not pass on the funds that they received to the other non-registered NGOs. In 2010, the 1976 Act was repealed and it was replaced by a stricter Act which introduced provisions. For example, it introduced a registration validity. Earlier, once you register it, you are permanently registered. Now it was reduced to 5 years and it had to be renewed after 5 years. Also, only 50% of the foreign contributions could be used for the administrative expenses. Earlier, there was no such limit. It could be used for any kind of expense. Then in 2020, there was a further amendment bill which proposed that the quantum of the administrative expense should be lowered from 50% to 20%. Also, the renewal of the registration after 5 years, it should be done after a similar level of scrutiny as the new application, plus the power to suspend the FCRA registration of the NGOs for more than 180 days, it was vested in the government. Now let us first observe what is the politics, how it has evolved regarding the foreign contributions in India. Normally it was allowed earlier to support the humanitarian relief, healthcare, education and environmental protections. And therefore there was no statutory framework either before 1976. The 76 framework provided the regulatory framework to control the acceptance and the utilization of the foreign contributions in India. And it was introduced because of the fear of the destabilization of the democratic system. That time also it was not prohibited, only regulated, but these regulations turned progressively stricter with every amendment. For example, the FCRA of 2010, there was concern that large-scale infusion of the foreign money into the politics can happen to disrupt the democracy, and therefore it prohibited the receipt by the election candidates, media personnel, public servants, judges, government employees, legislators, political parties, and even organizations of a political nature. They could not receive the foreign donations. Plus, it allowed the vesting of the assets created out of the foreign contributions in the prescribed authority under certain circumstances. These provisions have been proposed to be changed now, and the mandatory registration certificate was required for the organizations engaged in definite cultural, economic, educational, religious or social programs. Now, what are the proposals and the concerns under the FCRA Bill of 2026? Primarily, it provides for the vesting of the assets as under the section 16A of the Act, that the certificate, if it is cancelled, the registration certificate for the NGO, then if it is holding the foreign contributions, that it has received, plus the assets that have been created out of those contributions, they shall vest in the designated authority, which will be designated by the government. And the section 16A clause 2 even provides that if the asset is created only partly out of the foreign contribution, even then the whole asset shall vest entirely under the designated authority. And the vesting is provisional initially, but if the applicant is not able to obtain fresh license, renewed registration, or the restoration of registration within the prescribed time, then the vesting will become permanent. And the designated authority can even transfer such assets to any central ministry, state ministry, department, or even local authority, and the authority may even dispose of the assets via sale, auction, or any prescribed method, and these sale proceeds or unutilized foreign contributions, they will be sent to the Consolidated Fund of India. Another concern is related to the cancellation of the certificate, that if the central government deems it necessary in public interest, it can cancel it. But it will lead to almost unfettered powers, because the public interest, it is left undefined, it is vague, and also the assets can be forfeited, and those assets can even be places of worship. Therefore, particularly the Christian NGOs, they have been protesting, and the organization even loses the authority to receive the foreign contributions, and then the assets will be taken over, so their activities are effectively stopped. There is a provision related to the religious conversion also, that the registration certificate can be cancelled if it is prosecuted for religious conversion via force or via inducement. But it is extremely easy to file the complaints against the NGOs, and therefore once there is an allegation leveled, their registration may be cancelled. Therefore there is a potential for misuse of this provision. Another concern is a provision related to the surrendering, that if any NGO or organization wants to voluntarily surrender their registration certificate, then all the remaining foreign contribution plus the assets created out of the foreign contribution, they shall vest in the designated authority. So you are in a way punishing them for surrendering the registration certificate as well, that the organization is penalized even if they are no longer seeking the foreign contribution, if you are taking away the assets created out of the foreign contribution and the remaining foreign contribution. Plus the exemption clause, that is any organization, class, or person may be exempted from the bill if it is in the public interest. As per the author, it is violating the Article 14. How? That there is no intelligible differentia which is created for the creation of the exception, and there is no nexus between the legislative object and the creation of the exception. Let us understand this with the help of an example. For example, if you want to create an exception, if you want to carve out a class, and to ensure that the right to equality is not violated, then there has to be the intelligible differentia plus the nexus between the legislative object and the creation of the class. For example, the Indian Contract Act. Under the Contract Act, the minors are not allowed to be entering into a contract, because if the minor enters into a contract, it shall be termed as void. There is intelligible differentia. You are creating a class of minors. Any person who is less than 18 years of age can be identified as a minor, therefore it is intelligibly differentiated. There is intelligible differentia condition satisfied. And another condition, that is nexus between the object of the registration and the creation of the class. Therefore any minor, he should not be allowed to enter into a contract, otherwise it will make the contract void. The author argues that in this case, the exemption which is created, that is violating the right to equality, because both the conditions, the intelligible differentia as well as the nexus, they are not satisfied. The next article is related to the conflicts in the Red Sea and India's crude options. This is important in prelims under the topic current events of national and international importance. First, let us observe a few facts regarding the Red Sea. It is a semi-enclosed inlet of the Indian Ocean between the Africa and Asia. The northern portion of the Red Sea, it is bifurcated by the Sinai Peninsula. You can observe the Gulf of Aqaba and the Gulf of Suez, and it is further connected to the Mediterranean Sea via the famous Suez Canal. Now, the bordering countries are Egypt, Saudi Arabia, Yemen, Sudan, Eritrea, and Djibouti. The Red Sea has a peculiar characteristic, that its color changes as the algae blooms there, and geologically it is in a fault depression between the Arabian and the North African tectonic plates. The waters of the Red Sea, they are hot and salty, and there are 5 major mineral resources which are found in the region: the petroleum deposits, evaporite deposits, sulfur phosphates, heavy metal deposits. There are 2 islands of significance which you should remember: the Tiran Island, which is located near the mouth of the Gulf of Aqaba, and the Shadwan Island, which is at the entrance of the Gulf of Suez. Now coming to the article, let us observe that there are a few concerns for India because the conflict in the West Asian region has been widening. Earlier it was near the Strait of Hormuz. Now there have been attacks in the Red Sea as well. The Houthi militia is targeting the Saudi tankers at the Strait of Bab al-Mandeb. For example, therefore, the vessels that have been crossing the strait, they have dropped down from 43 vessels per day in the first half of July to just about 31 per day in the past 3 days. And the energy volumes which have been transiting through the Strait of Hormuz, they are still low. Therefore, India's energy concerns are there. The Saudi oil shipments have been facing delays as the tankers are forced to go westward via the Suez Canal and around Africa, which has led to higher freight cost. They want to avoid the Strait of Bab al-Mandeb because the Houthi militias are attacking them there, which leads to longer distance, higher freight cost, higher insurance cost, and therefore elevated global oil prices also because of the anti-Saudi blockade by the Houthi militias. And also the Saudi Arabia's east-west pipeline, the Yanbu pipeline, supplies about 3 to 5 lakh barrels per day if the Red Sea transit is allowed. Now, what are India's options if the oil supplies from the Saudi Arabia are hit? The primary fallback option for us remains the Russian crude oil. How? The crude oil which is coming from Russia, that also passes through the Red Sea only, but the Houthis are not attacking them. It is safe from them. And the Suez Canal, Red Sea, it remains the primary route as well. Now, amid the Hormuz crisis, already the Russian imports have risen from 1 million barrels per day in February to about 2.6 million barrels per day in June, and accounting for subsequently about more than 50% of our total imports. And before the war, more than 40% of the imports were from the West Asian region rather, and it was coming via the Strait of Hormuz. And at that time, the Russian oil was at a discount of $7 per barrel to Dubai before the escalation. Now rather the Russian oil is being sold by Russia at a premium because not only India, even China and Turkey are also competing for the Russian crude oil. Plus, another option is we can draw down upon our commercial crude inventories to bridge the temporary supply shocks which have been happening because of the attacks both in the Strait of Hormuz region and near the Strait of Bab al-Mandeb. We can also diversify towards our global suppliers. The alternative West Asian crude can also be explored by passing both the choke points, for example the UAE's Murban, which can be loaded from Fujairah port, which is outside the Strait of Hormuz, and it reaches India within 5-6 days. Another option is the American oil and the South American oil, but the problem is it is geographically far away, therefore it takes a long voyage time and it cannot be treated as an emergency replacement for the Houthi blockade losses. Plus, the Russia's oil exports to India, they have been also facing risks. For example, there is uncertainty because Ukraine has been attacking on the oil infrastructure in Russia, both the upstream and the downstream oil infrastructure. And the export infrastructure, it is critical, especially near the Black Sea terminals. For example, the Novorossiysk terminal. It is critical. Why? Because the export alternatives for the Black Sea ports, they are limited. And out of 1.1 million barrels per day which were loaded in June from there, more than 8 lakh barrels per day were coming to India only. And Novorossiysk supplied about 28% of India's Russian crude imports in June. And now there has been a tightening of the availability of the crude globally itself. And the Saudi Red Sea disruptions are having a relatively smaller impact on India. Rather, if there are disruptions in the Black Sea and therefore problems in getting the Russian crude oil through the Black Sea, it will have a larger impact upon the Indian energy supplies. But there are certain positives also. For example, the Russian operators, they are already accustomed to drone attack risks and they can rely on the shadow fleets. They have been running by shutting off their transponders, and there are more crude exports also Why? Because the Ukrainian attacks have also targeted the refineries in Russia. If the refineries in Russia go offline, they are attacked by Ukraine, they will have to export the crude, therefore there will be additional barrels available for export. But this will not last long, because Moscow will be prioritizing the restoration of its own refining sector. Therefore, right now it is forced to import fuel, because its own refining capacities, they have been curbed because of the attacks upon the refineries, the drone attacks by Ukraine. But once they restore it, then the export of crude from Russia, that will again come down. Therefore, it will cause again energy concerns for India. The next article is related to Guru Ravidas. This is important in prelims under the topic History of India. Guru Ravidas was also known by the names of Raidas, Rohidas and Ruhidas. His contributions are significant for the Bhakti movement, as he wrote various devotional songs, poems and verses, and his poems and verses are included in the Guru Granth Sahib and Panchwani text of the Dadupanthi tradition within Hinduism. He wrote poems in the local languages, therefore he had a significant impact, and he was a student of the Bhakti poet Ramananda. He was born in Sar Govardhanpur near Varanasi in Uttar Pradesh, and his birthplace is now known as Shri Guru Ravidas Janamasthan. He was a contemporary of Kabir. His philosophy included the rejection of the caste system. Therefore, he argued for the promotion of human rights and dignity. He envisioned for a society called Begumpura, that is a society without gum, a city without sorrow, which has no suffering, no fear, no discrimination. Therefore, he became a symbol of opposition to untouchability as well, and also promoted spiritual freedom, and therefore abandoned the Sagun. That is the Sagun form of supreme beings, that is the forms considered to be having attributes or images. Rather, he focused upon the Nirgun Bhakti, that is without attributes, abstract forms therefore. And he was considered to be the spiritual guru of Mirabai as well. There is a Ravidasiya community also formed by the followers of the Ravidasiya religion. They consider Guru Ravidas should be treated as a saint, just like the other gurus. He lived before the first Sikh guru, and his teachings were studied by the Sikh gurus. And even the Amrit Bani Guru Ravidas is treated as their holy book, and they have their own symbols and rituals as well. The next article is related to the Central Board of Film Certification. This is important in prelims under the topic Indian Polity and Governance. First, let us observe a few facts related to the body, the Central Board of Film Certification. It is a statutory body, functions under the Ministry of Information and Broadcasting. It is also known as the Censor Board popularly, and it functions although mainly as a certification body. It works under the Cinematograph Act of 1952 and the Cinematograph Certification Rules of 1983, as well as the guidelines issued by the central government. What is its role? It regulates the public exhibition of the films in India, and therefore no film can be released publicly without the certification from the Central Board of Film Certification. It has a chairperson and 12 to 25 members who are appointed by the central government. The CBFC has 9 regional offices located at Mumbai, Kolkata, Chennai, Bangalore, Thiruvananthapuram, Hyderabad, New Delhi, Cuttack and Guwahati. It also has advisory panels which comprises of members who are nominated by the government for 2-year terms, and its purpose is to assist the CBFC in the film examination. Now, what are the categories of certificates issued by the CBFC? The U certificate is the universal one, which is for the movies which are suitable for all age groups. UAE for the universal with parental guidance for the children below 12 years of age. A for the adults only. S certificate, which is for the restriction to special classes, for example farmers, doctors, and new subcategories after the 2023 amendment are UA 7+, 13+ and 16+. Now, coming to the article, it has been observed that the CBFC wields significant cultural influence by deciding which films can be screened in the Indian cinemas, and its decisions to excise portions from the Indian films, it is implemented even by the OTT platforms, streaming services, although they are not required to show the census version of a filmmaker's artistic vision. And these patterns of the CBFC's decisions, they are used for determining what kind of stories will be made in future,
And there is a reason why few political films that espouse the cause of secularism or that highlight the ills of communalism are seen in the cinemas today. For example, why would people dare to make a film such as Satluj, considering that what it went through at the censor's hands? And the censor board, as per the author, stands captured, as there has been a blocking of the films which are considered to be inconvenient to the ruling dispensation, and the only check upon its authority is the Cinematograph Act and the rules framed thereunder. Therefore, its autonomy is only on the paper. The CBFC is required to watch and rule on the films in a matter of weeks, but at times it does not do so. For example, for over a year, the film Monkey Man, which features a dystopian vision of a society with supremacy baked in, has not even been watched. So it amounts to a de facto ban when they are not even giving a decision, why not even taking a call. Similarly, the background references to the government's inaction during the COVID-19 pandemic, they were removed from Homebound India's entry to the Oscars. So there is a plain defiance to the Section 5A2 of the Cinematograph Act also, that the board has stopped publishing the certificates in the government gazette. Additionally, it has placed the online details of its certificates with the cuts unindexed and difficult as they are behind the under maintenance message. Also, the archives, they have stopped receiving the cut portions of the films for the researchers' study. Thank you.